Finch from the Licensing Service. I'll be presenting the report.
Philippa Bedette from Democratic Services.
And could I just ask the rest of the people around the table to introduce yourselves, and can I ask you when you speak to press the button on the microphone, one, because it's being webcast so that picks it up, and two, because my hearing's not what it used to be, so it's really helpful in this room if you can do that.
I'll speak up. Peter DeLange, I'm Chair of the Board of Portland Works, Little Sheffield Limited.
And I'm Anna DeLange. I'm here partly as his assistant, but I'm also a past chair of Portland Works.
I'm Carl Whittam. I'm a tenant at Portland Works. I'm Paul Lysiard. I'm chair of the incorporated charity Friends of Portland Works.
Bob Singh, Sheffield City Council Environmental Protection.
I'm Louise Glover. I'm one of the directors of No Mild Steel. The company's called No Mild Steel Limited.
And I'm Susanna Fullerton-Walker, and I'm the other applicant, the other director.
Good morning, committee. My name is Christopher Greenett. I'm a solicitor, and I'm representing the applicant this morning.
And again, good morning everyone, and welcome to the meeting today. Before we kick off, I will pass over to Philippa to give us our housekeeping arrangements for today.
Thank you, Chair. In the event of the fire alarm sounding, please take instruction from staff and stewards. The assembly point is at Tudor Square. Please can I request everyone to switch mobile devices to silent mode so as not to disturb the conduct of the meeting. The meeting today will be webcast, and the recording will also be available for people to view later through the Council's website. It is also possible that Sheffield Live TV will record and rebroadcast this meeting. While ever the meeting is open to the public, photography, video and sound recording of the proceedings is permitted. However, the Chair has the discretion to withdraw or suspend this permission. For example, if the recording is disrupting the conduct of the meeting or is being undertaken in a manner which could capture personal information, or in the event that a member of the public participating in a meeting objects to being recorded. Thank you.
So we have a set procedure for these meetings, which on our pages, on our papers is on page 72, and you will see at point 4 of that it says the solicitor to the committee will outline the procedure. So Sam, could I ask you to outline the procedure, please?
Thank you, Chair. Can I just check that everyone's had a copy of the papers? We have got some spares if you need any now, so Philippa can hand those round if you need an extra copy. As the Chair said, the procedure's right at the back of the papers, and I will try and get through it without coughing up along this morning. It looks worse than it is. So the licensing officer this morning, who's Shimla, will introduce the report. Any questions concerning the report can be asked by members and the applicant, so if there's anything inaccurate or that needs clarifying for the minutes, we'll get that sorted then. We'll then turn over to the representatives for the responsible authorities. So we'll head to Mr. Singh first from the Council's Environmental Protection Service, just to detail his relevant representations. And members, and with the leave of the Chair, the applicant can ask questions of Mr. Singh, and you will also have an opportunity to ask him questions as well. Following on from that, we'll turn to the interested parties, so each of you will all have the opportunity to have your say, just to detail your representations in the report and to respond to anything that's come to light since. And again, members and the applicant may have some questions for you as well. And we'll then head over to the applicant and their representative, just to detail the application, provide clarification on the application and respond to the representations made. So that would be quite helpful because there's been quite a lot of changes since the application was first submitted, so it would be good just to have everybody singing from the same hymn sheet on that. Again, members can ask questions, you guys can ask questions, and Mr. Singh can ask the applicant questions as well. And once we've done with all that, the applicant will be given the opportunity to sum up the application. We'll then take the options from the licensing officer, which are detailed in the report, and we'll go into private session while members take legal advice and consider the application. The decision of the Licensing Committee will be given in accordance with the requirements of the Licensing Act 2003 and regulations made thereunder. At any time during the hearing, members can request legal advice. We can either do that in open session, as we are now, or in private session, where we just ask you to wait in the room while members take legal advice, and when we invite you back in, we'll feedback what that was and what the outcome of the advice was. And as Philippa said, the hearing is in public this morning, so it is being live webcast. And obviously, as Philippa detailed, the exclusions may apply if there's anything that we consider prejudicial that needs to have the recording paused, but hopefully it should be relatively straightforward this morning. And I think that's everything. Thank you, Chair.
Thank you, Sam. And basically all that means is everybody gets the chance to say anything they want to us. We get the chance to ask you questions, and then we will take into account everything that's been said and come to a decision based on the legal position. So could we have the report then, please, Shimla?
Thank you, Chair. And this report is to consider an application for the grant of a premises licence under the Licensing Act. The application was submitted on the 2nd November by No Mild Steel Limited. A copy of the application document submitted and proposed plan is attached to Appendix A of the report. The application has been referred to the Licensing Subcommittee due to unresolved representations from responsible authorities and interested parties, which are listed in paragraph 3.1 of the report. Full copies of the representations are attached to Appendix B. During the consultation period, the applicant has agreed conditions and a reduction of operating hours with South Yorkshire Police. Details of this can be found at Appendix C of the report. Parties have been updated with these changes. Since the publication of the report, the Health Protection Service has been liaising with the applicant to resolve the issues raised in the representation. An updated plan has been submitted, and all 5 conditions listed in the objection have been agreed, and the objection has been withdrawn. Copies of the conditions and the plan have been circulated separately to all parties. The applicant and interested parties have been invited to attend the hearing. There are no specific financial implications arising from this application. However, additional costs may be incurred should the matter go to appeal. The legal position is detailed in paragraph 5 of the report, and it's recommended that members carefully consider the representations made and take such steps as the subcommittee consider appropriate for the licensing objectives. Thank you, Chair.
Thank you, Shimla. Do members have any questions regarding the report at all? No. Does the applicant have any questions regarding the report?
No, thank you.
Do the interested parties have any questions regarding the report?
Not from me.
If not, then we will go straight to the responsible authorities to outline your objections today.
Thank you, Chair, members. I'll try and keep this as brief as possible. I work for Environmental Health, Sheffield City Council. We've formally consulted on the premises licence application, and we consider the core objective relating to the prevention of public nuisance. We reviewed the application. We noted the initial application had extended hours until the early hours of the morning at weekends. And we arranged a joint responsible authorities meeting on site where we met the applicant. Very proactive applicant. We offered our advice and guidance, and we considered the fabric of the building. Very large open space. I'm not sure if you guys have visited at all site. We're talking about an old commercial industrial building, not acoustically designed for an entertainment venue to include live recorded music, etc., etc. And we have a number of weak points in the fabric of the building. So you can imagine we've got an all-star tin roof, several openings, single glazing, roller shutter doors, so we don't have any means of lobby designs, etc., etc. It's a bare brick building. It's not been acoustically treated. Very minimal sound insulation. If we have a normal conversation, for example, like this when we were on site, a dozen people, the reverberation is significant. Therefore, our concerns are if any amplified sound is present at all, being played at above background level, it will result in, my professional opinion, noise breakout given the current existing fabric. Let me just firstly address commercial v domestic. We have some residents on Hill Street, approximately 30 metres away from the actual premises in question. We know what the residents are like. Over several years, they are sensitive. The reason being, neighbours who are probably present here are aware we've investigated noise nuisance complaints against individual operators, music studios, etc. in the vicinity, and we have secured, imposed additional noise control measures, you know, reduction in hours, improvement in sound ventilation works, etc., etc. So that was the concern. We discussed and made recommendations initially. You'll find in the committee report. We recommended, in conjunction with the police, a reduction in hours, 2,300 hours for all licensable activities across the week on any day. That was accepted by the applicant, which is absolutely brilliant. And we recommended several noise conditions. I'll go through them briefly. The first two conditions are probably the most important conditions. Following the actual inspection and the current fabric of the building, we believe that anything applied above background level will result in noise breakout and transmission. And this will be at any time of the day, not post 2,300 hours. I don't think it's any fault of the actual applicant. I think it would be any occupier. It's down to the design of the actual building itself. So we recommended no live or recorded music is played within the building unless a scheme of sound attenuation works is installed, and that's a noise survey is undertaken by a competent acoustic consultant to design in accordance with Sheffield City Council noise standards. That can go on. If you'd like me to question the technical side for it, I will do. Following the scheme of installation of works, then we've asked for the consultant to carry out validation testing to confirm the scheme installed is satisfactory, and our standard in condition 1 equates to inaudibility at the nearest noise sensitive property receptor. That's the residential dwellings. And then we've got standard conditions. So, for example, all doors, windows shall be closed, save access egress, general member, general public, or in case of an emergency when amplified sound or live music is present in the premises. I've just got to point out with this condition 3 that potentially may be a conflict with health and safety and fire regulations, because we've only got current roller shutter doors present on site, so they have to remain open in accordance with fire regulations, resulting in direct noise breakout. We've asked for no speakers to be fixed externally, no amplified sound within the building played through a noise limiter in a tamper-proof manner. We've asked the DPS to take a proactive approach in respect of noise control, noise breakout, access egress, the external designated area, managing noise from patrons whilst using the facilities provided. 2 conditions in respect of signage. Please leave in a quiet and orderly fashion when exiting the building and within the designated external area. And a noise management plan of operational procedures A to Z, anything to do with noise management while the premises is open. Following our initial representation, further discussions were held with Suzanne. Proactive. I must point out the fact they have been very proactive throughout. We discussed the financial costs involved in carrying out an acoustic survey. Given the size of the building, the improvement works, we're not going to be talking tens of thousands. There's going to be significant cost. The applicant confirmed finances are very limited. We need events and temporary events to start to bring the money in to carry out the improvement works in a phased manner, etc., which we acknowledge. There'll be less risk of events, so our initial concern was you could use the whole building as a capacity, as a potential rave with a full production, but that's not going to be the case. We were talking about Christmas fetes with a brass band, comedy nights, I think bingo bango, something like that. So music would be considered ancillary. Following our discussions, we've lessened our approach in terms of conditions 1 and 2, where in the initial representation we requested that we require the noise survey to be completed, all the works to be installed prior to live and recorded being played, and validation testing to be secured. But in our amended conditions, what we have asked for is we've just included our technical standard of no more than 3 dB above background, which equates to inaudibility. So we've not asked the applicant prepare the noise survey. No details are submitted in terms of the scheme attenuation works up front. The applicant would play live and recorded music at their risk. And then we've introduced a couple of new conditions where condition 2 would kick in if any justified complaints do arise following our investigations or complaints. Of course, we'd work with the applicant, and if we feel the nuisance investigation was validated at the nearest sensitive receptors, etc., then we'd ask for the condition to kick in where no live and recorded music is played, and we would require the submission of a noise assessment to be completed. So we've relaxed our approach. We want to work with the applicant, and that's where we are commercial v domestic. Following such, and reading the committee report outlined by several representations, we also have the issue of commercial v commercial. So we have several commercial premises operating from music studios, little artisan workshops, etc., which I believe parties will advise you later. In terms of noise transmission, now the technical standards are very different to domestic properties, because if you have a look at the distance attenuation, we're just looking through a party wall structure. So you're talking less than 1 metre, then you're in a neighbouring property. As previously explained, the current existing fabric has no insulation at all. We're probably talking about a single skin brick wall on some elevations. So if you are operating at maximum capacity, which they've requested below 499, which they've amended, and probably any form of music played at above background level, it will be audible in our professional opinion, and dealing with similar venues across Sheffield and the impact on commercial neighbours. So we can design to that, but we haven't recommended a condition to address commercial v commercial. So, the committee, Chair, you've got options in terms of which I need to seek advice from you, because I've noted the applicant solicitor has provided a formal written representation in terms of the application of conditions. Given the applicant has reduced hours to 2,300 hours and reduced the capacity to 499, live and recorded music falls under deregulation, as you're aware. And I need to seek advice from committee and council for legal opinion, whether we can apply conditions to the premises licence in this respect, and I'm sure the applicant solicitor will provide further information on this, and if such is the case and we cannot apply any conditions, then we've got grave concern really that we have no protection or level of protection to domestic residential dwellings and commercial neighbours. Please note from our side, we need to be seen to be business friendly. We want to work with the applicant. We are not against the applicant. We don't want to put any physical barriers. It's just unfortunate the building they wish to occupy is in a very poor state acoustically. There is a significant financial commitment that is required to improve the fabric, and our professional opinion is it will have anything above a background level will result in complaints affecting domestic and commercial. No further comments to make.
Thank you, Bob. Sam, would you like to provide some legal clarity?
Yeah, I think I will say it's general legal advice rather than to the EPS specifically, because my role is actually to advise members, but just to clarify, and in discussions with the applicant and Mr. Grunet, that the Licensing Act 2003, now live and recorded music, was deregulated. So by virtue of the Live Music Act in 2012 and the Deregulation Act in 2015. So where a premises has an alcohol licence, which they're applying for, and operate at a capacity below 500 people, which they're also intending to do, that live and recorded music is deregulated between the hours of 8 AM and 11 PM. So we're almost at a bit of a moot point really. There's not really a regulated activity in terms of that music in order for us to be able to apply conditions, in order to apply further restrictions to that, because the government have deemed that the trust should be put on the premises. We work on the stepped approach and work from the basis that premises will always operate responsibly and considerately, that they'll have taken into account other venues nearby, and that they will address those matters in their operation. Obviously, and as with other premises, if it transpires that when they are open and operating, that there are problems, people can make complaints. You know, we've got licensing, we've got the environmental protection, we've got health and safety as well if those issues are triggered. And what we do then, that stepped approach kicks in. So it might be an informal discussion with the premises, or it might be something more significant. So they can review the licence, it can be brought back here, and we can say, actually, you know, the live and recorded music is causing a problem. We're not satisfied that you're operating considerately and respectfully to the residents. So we're going to put some further conditions on, or in the extreme, we may even revoke the licence from the premises. So they are the options, but the starting point essentially is they can provide live and recorded music between 8 AM and 11 PM without the members' discretion being engaged, essentially. That is the position we are in. If they were operating outside of those hours, then the conditions will apply. So if they were operating until 2 AM, the conditions would start at 11 PM and run until the licensable activities cease. But because they have been deregulated, the premises are able to provide those by virtue of having, or hopefully having, the alcohol licence in place. But I don't disagree at all, so probably explain that a lot better than I have and a lot more succinctly. But hopefully that clarifies. Obviously, if there are any questions going through from anybody, then one or both of us are quite happy to address those. Thank you.
I have a question. It might be clear to everyone, but nothing's ever clear to me. Just in terms of public nuisance, I mean, there are non-licensable activities, such as, you know, chucking glass bottles into bins. It's not a licensable activity, but we can put conditions on to control that, to prevent public nuisance. Where do we stand in terms of, you know, it might not be a licensable activity, but can we still put conditions on to prevent it causing public nuisance, or are we stuck?
Yeah, so for the more general noise element, so we're still looking at the 4 licensing objectives. So if we have got concerns, sorry, I was doing so well, in terms of the more general matters, that would be a matter for us sort of looking at the circumstances once we've heard the applicant's case. But like you say, with the notices and the general potential noise breakout, that potentially is something that we can condition. And like you say, with the general nuisance of waste and things like that, you could, but not specifically in relation to live and recorded music. So the limiting of the sound levels, I would say, is not a condition that you could put on. But to ask people to leave the premises respectfully if you hear something that would warrant that condition being in place, then that generally, for general noise breakout, I would say yes.
Thank you. I think I'm clearer. Have members got any questions for? Well, shoot away.
Good morning. One of the things, I don't know whether it's an ironic title, No Miles Steel, whether it refers to a particular type of music, but like heavy metal, or whether the premises used to produce mild steel. But the question I've got to ask the environment is, as these were commercial and industrial premises before, what was the activity that was going on before? What sort of noise level was pertaining at that point, and over what sort of hours?
Well, thank you, Councillor. Probably before my time. It was probably engineering, manufacturer works, etc., before I'm born, and I was born in 79, so I'm unsure. We're unsure what particular noise break levels were permitted there. The residential come along, well, 60s, 70s, a long way prior to this actual particular building. There's no planning restrictions in terms of operation hours for the building itself, 110 Randall Street, because that was confirmed by planning. And that's about it. Sorry, I can't clarify any further information in respect to your questions, to be honest.
Yep.
Say something.
The building was previously used by Olympic Stainless Steel, who'd been there for, well before my time. I've been there for 10 years. and they were involved in fabrication of stainless steel. And they worked between the hours of 7 in the morning and 5 in the afternoon. And it was never a nuisance at all.
Yeah, I wondered on the actual report when you're going to be open some particular weekends till 6 o'clock in the morning. What sort of event is that going to be?
Is it that, I'm happy to answer that question. I appreciate I would. Well, I will clarify that, Councillor, in my representation there.
So, just from me, I mean, from what you say, the building isn't great in terms of noise limiting. In fact, it's pretty bad. Are you satisfied that the things that you are recommending here would control noise breakdown?
Yes, because in terms of the conditions, condition number 1, we're asking they seek professional advice from a competent acoustic consultant. They will carry out a noise assessment and noise survey, prepare it in accordance, design requirements in accordance with Sheffield City Council standards. These are our technical standards. For example, what recommended in condition 1, no more than 3 dB above background, equates to inaudibility at the nearest noise sensitive receptors. So at any time of the day, if they install that survey will recommend a scheme of sound attenuation works, i.e. improvement to the roof, the glazing, lobbies, sound insulation, party wall structures, etc., etc. And would also ask for advice in respect to the potential impact via transmission on commercial neighbours. The financial commitment to install the scheme probably be excessive, significant, given the size of the actual building, but once all installed, that's when we ask for validation testing that it satisfied the requirements. So the answer to your question is yes, we would be if everything was implemented here.
Thank you. Sam, do you have any questions for environmental protection?
Yes, thank you. I think you did touch on it. So the concern is not just from the films, the music, the events that are put on. Is it just all noise?
It's all noise. Concern? Yes, it's all noise. All noise.
Okay. That's fine, thank you.
Do the applicants have any questions for Environmental Protection Services?
Just to clarify, please, Chair. So, if I take page 43 of the bundle, which is your representation, I don't know if you have a copy of it, but this is the amended representation following the reduction of hours. Just to clarify, you're looking for condition 1 to be applied with immediate effect, and then the later conditions to be applied only if Environmental Protection Service receives a justified noise complaint.
Correct, yes, that's correct.
So the committee is being asked to grant a licence based on the first condition alone, and only the second if noise does, a nuisance does occur. Although you said to the committee there that this related to noise generally, on the conditions, they do seem to refer to live or amplified music, speakers, for example, no amplified sound, DPS to take a proactive approach to noise control, checking outside the premises to ensure noise is kept to a reasonable level from patrons in the designated external areas. The premises licence holder shall display notices, polite notices. The premises licence shall have display notices in external areas reminding people of the locals' needs. So of the conditions of the additional conditions, which you're not asking the committee to put on today, but may come on if you had complaints, I think 6, 7 or 8 are the only ones that aren't directly linked to live music.
Just to clarify, may I respond, Chris? Sorry. And this is why I need to seek clarity from our legal, is under deregulation, is it solely conditions in respect of live and recorded music that cannot be imposed? Because apart from conditions 1 or 2, and the noise limiter condition, we would require all the application of the other conditions made in the initial representation and the amended condition 1 and 2. But if we can't, then we have to remove everything from to deal with live and recorded music. But I need to seek advice from our legal opinion in respect to that matter.
We're all pressing buttons.
And I think we'll be seeking legal advice in private session as well when we come to a decision on this. We need to. Well, we can only work within the legislation.
Sorry, Chair, just to finish that off, my view would be the same as Mr Grunett's, that only 6, 7 and 8 would, if the application is granted, would be possible to apply. So we can't apply conditions specifically in relation to the live and recorded music. We can, if there's evidence before the committee, evidence that the provision of films will cause a nuisance, conditions could be applied in relation to that regulated activity, but not to the music itself now.
Thank you. So if there are no more questions for environmental protection, I move across to the interested parties. Would you like to kick us off with...
Thank you, Chair.
Speak up.
Not sure I want to say very much more. I'm grateful for the clarification on what confused me was that on page 34 of the bundle, which was that the applicant seemed to be applying for things for which they didn't need a licence. I now understand it a lot better. And if I caught the last exchanges correctly, you can't impose conditions initially, but if there is a complaint on live and recorded music, you can impose conditions on things which are not live and recorded music, but you have to wait for a complaint to do. Okay. Our concerns, I mean, it centre on the noise issue, which is, as I put in our representation, paradoxical, because we've got one forge with a spring hammer, we've got a blacksmith using an anvil, we've got rock bands practicing, we've got 2 knife makers grinding blades, but actually for most of the time Portland Works is very quiet. The noise is intermittent and is easily resolved if there's a conflict. As I say in our representation, that would not be the case if there's a 4-hour whatever generating noise in steamworks. Much more difficult to resolve. I do refer in my representation to some other aspects. If I can just find them. Yes, parking, crowd management and security. But in discussion with the applicants, I think, I would hope that they can be satisfactorily managed. Our main concern remains the potential for public nuisance caused by sound, particularly on the units which are immediately adjacent. I don't know about the single skin wall. I think there are 2 skins. I would hope that Portland Works has got one wall and that one Randall Street has got another wall. The current tenants tell me they've never heard sound through the wall from the previous operation, which must have involved stamping, metal stamping, grinding, sawing. So perhaps the insulation is better than we expect. But I'm glad that environmental protection have picked up that it's not just the residences 100 metres away, it is us immediately adjacent. I think given that it's already a licensed activity, the music aspects, we must just suck it and see. And I'm sure that our tenants will let me know very quickly if their operations are interfered with by the adjacent event space. I think that's all I want to say at this time, Chair. I'm happy to try and take questions.
Thank you. What I'll do, I'll take all the interested parties first and then open it up to questions. Then you can all come back with the answers because you may all have issues. So would you like to give your concerns today?
Yeah, I'm a tenant, as I said before, of Portland Works. I've got a studio, a photographic studio where we also produce video. The working hours are roughly 9 in the morning while up to 10 o'clock at night. It's also a higher space. Other people hire it to produce videos and take photographs. I have an adjoining wall with the premises that we're discussing. And so obviously my major concern is sound ingress into my building from next door into my space, which would seriously have an effect on my business, which has been there for 10 years. And that is my representation, basically.
Thank you. Yeah, it was very clear in the objection that you put in as well, the impact on your business.
Yes, so I chair a charity which has the primary aims of raising grant funding to invest in Portland Works which is a Grade 2 star listed building. We also have an education and outreach function about educating people about our heritage. And for the last few years, in fact last year, Friends of Portland Works took on the job of organising lectures on only monthly, once a month in our makerspace, which the back wall of which directly adjoins 109 to 111 Randall Street. So my concerns remain really, it's to do with noise. It's less to do with the business model of the neighbours. We obviously support enterprise in what is a fairly deprived area of Sheffield, and anything that brings a bit of prosperity into the area is to be welcomed, obviously. But having heard the environmental health gentleman's comments about the suitability of the building, I'm not sure that my personal concerns about noise will be satisfied until I know that the noise survey has been carried out and that I know what mitigation is being put into place, because I have to say it does sound like a very substantial investment that would be required in order to keep the noise level down to the legal limits. So I'm very grateful to now have learnt more about the plans and where we are, but it seems to me that there's another stage to go before we actually know what mitigation is being put into place in terms of soundproofing, single glazing, ingress where you've got the gates have to be open, but an event's going on inside, so you've got noise pouring out of the entrance. All those sort of issues, which I think you've alluded to, are ones that I would like to see resolved. Thank you.
Thank you. That's helpful. I'll open this up to questions now. Anne, is there anything you'd like to ask the interested parties at this stage?
Not at this stage, no.
Roger?
No, not at this stage. No, I'm happy with what.
Can I just ask a question for all of you? Has there been any contact with the applicant? Has the applicant actually tried to talk to you and tried to resolve matters during this process?
I think I've had 2 meetings with
Brief conversations.
With the applicants. They've reassured me on certain aspects such as security and management of crowds. But I think it's fair to say that given the nature of their business, we can't be and the nature of their business and the character of the building, which has already been referred to, it's not possible to give us an assurance that there won't be any noise interference and transmission until it's actually tried and tested.
Could I just ask you then, when the applicants, when they came to say, look at the premises, I assume that you must have shown them the premises. Did they say what they were wanting to use it for?
We had the notification of the application.
How did they come about renting it? Do you not have the leases? No?
Sorry?
Do you not rent the building out? No. All right, that's what I wanted to know. I just wondered how they'd come by the...
Do we own that building? No, we don't.
No, but how did they come to know the premises were available? Who It doesn't come through
The
you.
premises they have taken a lease on,
Yeah.
well, the previous company was either Olympic or Olympus. I can never remember the name of it. It's one or the other, the stainless steel fabrication. And they went bankrupt.
It's nothing to do with Portland.
And it's nothing to do with Portland Works.
Oh, right. Okay. Thank you.
Okay, can I just ask, I'm terrible on names, I have to say, the gentleman in the middle. He sounds like the noise breakout would be sort of a disaster for your business. I wonder if you could just expand on that, you know, how often, you know, other things you do that it wouldn't impact on, but just tell me a little bit more about the impact of it.
Well, it wouldn't impact on photography as taking a photograph. I mean, it might be a little bit difficult. It's a job that requires concentration, and it's nice to work in an environment that hasn't got, you're not being hammered with sound. Other aspects of it are video recording. Obviously, anything to do with audio with video would not be able to take place at all under the circumstances of music being played next door without some quite substantial soundproofing. So it would curtail a number of things that I actually do, including hiring the space. People hire it for video. It would be very difficult. I can't imagine people coming back if they turn up to shoot some video and then can't do it because of noise next door. That's basically the impact.
Thanks. So a significant impact, you basically stop most of your business.
Is it a recording studio that you have as well?
Mine isn't a recording studio, but there is a recording studio. It's on the first floor? Yeah. On the first floor, just to the adjacent my building, which also shares a party wall with the building. And they record music there, yes. So it would affect him as well.
Usually recording studios are well insulated.
Yeah, but it's very difficult to stop this kind of heavy-duty bass music passing through a wall. It just happens. You can't insulate for that, I don't think. Not to my knowledge, anyway.
We wanted to come in on that point, please do.
Please, Chair. Thank you. I think just in summary, there are 3 units in Portland Works which are adjacent to 109 to 111, which are sensitive.
4.
Well, 3 principal ones, which are, would you think of Hackspace?
Yeah.
Hackspace have got, no, it's lesser. 3 principal units which adjoin the other premises, which would be sensitive, particularly sensitive to sound interference. One is the photographic studio and videographic studio. Another one is a pure sound studio. It's a practice room, and they've got an sound insulated room for recording. And then there is what we call the maker space, which Paul has referred to, the space which is ours for use for events, hired out for events, for lectures. Any of those could be impacted and the effectiveness by noise interference, to the point where this is where it's paradoxical about the noise we make ourselves in the works. If our blacksmith is hammering away at his anvil and we've got a booked event, then it's a question of accommodation between going to talk to him and say, will you stop hammering on your anvil? If there is a booked event at Steamworks, music, film, which has got sound coming through the wall, it's far more difficult to reach that sort of accommodation on an ad hoc basis. And even if we are notified in advance, we could still find a conflict between an outside person who's booked our event space and an event ongoing next door.
Thank you. Sam, have you any questions for the interested parties?
Yes, and for Bob as well, if I may. Sorry, they are linked. Just jump around a bit. So I understand the premises have already put on a couple of events so far under temporary event notices, and just wondered if they'd caused any issues so far.
So other than parking, no.
From our point of view, I did discuss this with Chris and the applicant earlier on. I wasn't aware that any temporary events had been formally submitted, only over informal discussions, and it looks like a Christmas market was undertaken. I believe, well, this is a question for the applicant really, if you could answer, if not, there was going to be a brass band played at a Christmas market. I'm not sure if that was undertaken, but in terms of complaints-wise, we've not received anything, if any events have taken place.
Just to come back on the brass band, we didn't play the brass band. We have controlled the premises and we felt the brass band wasn't appropriate. And therefore, that's, without giving you a trailer to my representations, that's an important point to make.
Sorry, I missed that. Can you speak into the microphone?
I was a bit close. Sorry, sir. No, there was no brass band playing at the event. It was considered, but we decided not to go ahead with a brass band on reflection. That was how we chose to manage that event.
Sorry, it's actually for Bob again. I've gone all over the place here, sorry. You mentioned residents sort of to the rear of the premises, and that you'd had complaints about noise from other buildings.
Over the years.
Is that sort of relatively recently, or is it sort of quite constant?
Historic.
Historic.
Not recent.
Okay.
If you'd find post-COVID, no complaints. It's historic issues with some of the operators. Several of the little commercial units, Portland Works, Stag Works, in the vicinity of Randall Street, etc., etc. And those are from the residents on Hill Street, but nothing in recent years, post-COVID.
That's great, thank you.
Press the right button. It's only two. I got it wrong. Do the applicant have any questions of the interested parties?
One, Chair. Mr. Whitten, thank you for your representation. You said you've been in your unit for about 10 years. Did that overlap with the industrial use, former industrial use next door? Thank you very much.
And so, in the absence of any further questions, it's over to the applicants to state your case to us today and to respond to the representations that have been made.
Thank you very much, and again, thank you for everybody attending today and participating in the hearing. We do appreciate that it takes up people's time, and we don't take that lightly. This is an application by No Mild Steel Limited, which was a much wider, more flexible licence initially applied for, but is now being curtailed to the hours described before you. Just to recap, the retail sale of alcohol between noon and 11 p.m. Monday to Saturday, noon and 10:30 p.m. on a Sunday. Following our legal representations, we're not strictly applying for live recorded music or plays, and that those forms of entertainment will be provided in a deregulated format. So we wouldn't be asking the committee to issue a licence permitting those activities. If you did issue a licence, for example, saying live music between X and Y, then we could, in theory, go beyond what is the deregulated limit. And we're not at all asking the committee to do that today. The regulated activity in form of entertainment that we're asking for is film. And film is a very small part of this premises use. I think the event that was envisaged, and one of the few events that was envisaged for that would be Home Alone, was it? Yeah. Home Alone as a Christmas film, being a Christmas sort of family event in the lead up to Christmas, a showing of that. But it's not going to be a cinema, it's not going to be a regular format of operation at the site. The premises is not a nightclub, it's not a bar, it's not a exclusive live music venue. It is a space that can be utilised for a number of purposes, those of which could be included technically, but for the hours that we're seeking, for example, it's not a late night bar, it's not a nightclub finishing at 11 o'clock in the evening, it's not moving towards those. But the sort of events that we have had most recently was a Christmas market, where around about 100 local independent businesses were given a space to open their Christmas market and to sell their goods and wares, and that event appeared to go off without an issue in respect to licensing objectives operated under that temporary event notice. Live and recorded music even in its deregulated form, can take place across a spectrum. Background music up to, I think, heavy-duty bass music and things of that nature. Of course, there is a spectrum of it. And my clients recognise that the unit in its current format is not suitable for all forms of live and recorded music. And that certain live and recorded music events, if they were operated tomorrow, would undoubtedly undermine the licensing objective. And we're not asking for you to give us permission to do that today. You can't give such permission, but we are aligned to the licensing objectives. It's not my client that's chosen to deregulate these activities, and they've been deregulated now for 8 years plus. And the basis is that it's a permissive piece of legislation, and the starting point, I think, as your legal advisor summarised, without wishing to put words to mouth, is that you're allowed to move forward on the basis that you'll operate in a responsible manner, promoting those objectives, but there are checks and balances. And I disagree with Mr. Singh that there aren't checks and balances if you don't issue these licensing conditions. That's manifestly incorrect. Mr. Singh has numerous and considerable powers, the most significant of which is the Environmental Protection Act 1990, which allows Mr. Singh and his colleagues to issue things called noise abatement notices, which require premises to abate the noise immediately. I can see what we can see what Mr. Singh can do about that at a later date, and those carry criminal consequences in forms of fines, etc., and lead to quite difficult legal formats. So although Mr. Singh is pretending that he's harmless, he's reasonable, but he's far from harmless, and he has many teeth that he can use to regulate this premises if it was deemed necessary. The Act itself, the Licensing Act, gives Mr. Singh explicit powers to come back and ask for a review of the premises licence, to disapply the deregulation. If my clients show that they can't be trusted with it, and there's evidence to that, he can present that to you as a committee. You will consider that evidence, and it's within your purview to say, well, we're switching off the deregulation, everything is now regulated, and either you can't have it at all, or you can only under these strict conditions. But there is a process, and that is the end of that process, a stepped approach as it was described, and I think that's correct. The conditions that Mr. Singh is asking for today, which followed the curtailment of my client's licence, are in your report at page 43 onwards. But in essence, they fall into two parts. Firstly, he asks for amplified sound or live music shall only be played within the building at a certain level. And that's 3 decibels a metre away from the nearest noise-sensitive premises. That's not at the front door of the premises. So sound coming out of a premises, and what Mr. Singh is looking for in his representation was inaudibility. And he's talking about inaudibility for a residential noise-sensitive premises. Whether inaudibility is the right level in matters, if that's a public nuisance, or whether we live in a society, in a world that makes noise, and not all noise is absolutely a nuisance. There is a scale, is possibly a debate for another day. My client is acknowledges that level, and in respect of that, we've asked for a condition to be amended, not for amplified sound or live music, but for film, which is the regulated activity we're providing. We're not going to come before the committee and say that Mr. Singh is speaking out the top of his hat and that he's asking for unreasonable matters. What we're saying is that the conditions we propose, you can make, and it would be enforceable, and we acknowledge that as a reasonable level. The advice that Mr. Singh has given subsequently in respect of other conditions, which would be perhaps best practical means to control the noise, we don't disregard those and say, again, they are a nonsense. What I'm saying to you is that it will cause confusion for objectors, the applicant, services, enforcement officers, to put conditions on a licence to control music at this stage, which would be unlawful. And you can't regulate using those conditions. My client could have simply closed their lips, accepted them on, said about the objectives, well, we've agreed all these conditions, but we would know that they were unenforceable, and I don't think that's the correct way of proceeding. Of the additional conditions, so conditions on page 44, 3, 4, 5, 6, 7, 8 and 9, Mr Singh is asking for those to be applied to the licence if and only if he receives a valid complaint, is how he describes it. And I'm not a big fan of that wording. It's a little bit imprecise. But what it also does is it usurps the committee's power on review. What he's saying is, if I receive a complaint, I'm going to re-regulate these deregulated activities and these conditions are going to come on. There's going to be no application for review, no opportunity for my client to obtain evidence, to rebuff those matters, to put other proposals to you as a committee and say to the committee, well, this is the correct solution. Mr Singh can say, that is, we may be both in agreement, but it short-circuits that process. And again, I think that's simply not envisaged in the Act is unlawful, and it would be folly for you to do so. But those checks and balances are there. And one thing that is also there from the third moment is the need for my client to promote all 4 of the licensing objectives, including prevention of public nuisance. And they are alive to the issues of their neighbours. They have engaged with their neighbours. They've engaged with the police. They've engaged with environmental protection as well. And we have agreed conditions. They're not sticking their heads in the sand and refusing to engage. They've met the neighbours and tried to explain the eclectic nature of the kind of operation that they're going to run. It isn't going to be a single thing with just relying on live or recorded music. For example, it's not a nightclub. You know, we've tried to make that and those explanations across. What we hope to see is it be a community space that can be used for lots of different purposes. But whatever purpose we want it to be utilised for, it will be subject, if you grant this licence, and I suppose only if you grant the licence, to the licensing objectives, including prevention of public nuisance. By granting the licence, you are then putting a burden on my client to promote those objectives which aren't otherwise there. We understand the concerns of neighbours and essentially it's a fear of slightly of the unknown without a track record, a matter of trust, of stepping over the line and relying on my clients being responsible operators and good neighbours. I think that is the position that the committee should fall to. We're grateful to the Port that works in their sort of submissions that essentially that's the position they find themselves in. They may not be happy with that position, but I think that is the correct way to approach this. It's not to suggest that my clients would be operating inappropriately. I agree that there is acoustic works to be done. My clients are planning to undertake those and build towards those substantial costs that would be involved in undertaking those. And until such time as they have satisfied themselves that those events, perhaps live music, louder live music events, could be controlled and could be taken in process, they simply won't happen. As I say, we're not asking on the licence day for you to say, yes, you can do live and recorded music. It's actually silent now on that point at all. So we are discussing entirely deregulated activities. Although Mr Singh is asking for those additional conditions to be imposed only if he receives a complaint, conditions 6, 7 and 8 of page 44 of your bundle of reasonable conditions, and we are happy to sort of take those on board without a complaint being necessary. They reflect my client's intended practices in any event. They just come under a heading, and it's the heading more than what comes after it is what we have a concern for. There has been a industrial use of this unit going back a number of years. In the representations before you, there isn't evidence that in itself has caused issues. I think, therefore, it's reasonable for the committee to come to the conclusion that there is a level of noise and serious operation of this building that can go on without disturbing their neighbours. We're not saying to the committee, however, that is limitless and beyond all scopes. We want to reiterate that we do recognise that. But heavy-duty bass music being blasted at full volume at the party wall is not a lifestyle activity that we're envisaging. And no reasonable operation would, I would suggest. I think in the representation there is reference to a loud piece of sound that does disturb on a single occasion. But that was actually an acoustic testing piece of kit that unfortunately its purpose is to find where the limit is. That sound that is reported in the representation is not from our own PA system or our speakers. It was from a piece of kit brought in except just with the extreme purpose of finding that level. I can only reassure neighbours that is not typical at all of the level of music that we experience or intend to prevent or provide there. And we hope that we'll be able to peaceably move along. Again, as all neighbours, we will engage with our the people next door. We're happy to provide contact details directly to the Portland Works so that they can get in touch with us at any moment if they want to discuss any aspect of the business there or then. Correct that they do not have directly control over us, but my clients are reasonable individuals and of course they'd be remiss not to respond positively to complaints or proactively to those complaints. Save for that, I'm not going to spend a lot of time going over the police conditions or the Environment Protection Service. They are not matters, I think, that are relevant now insofar as the objectives, including Mr Singh, don't cite them as areas of concern. And those authorities have now expressed their contentment with what we've agreed. But what we're asking for, essentially, is retail sale of alcohol and film. And we can also, on film, if the committee felt that it should be limited to a number of occasions per year, that's something that's a liberty for you to do. As I say, it's not an event that we will be offering every week or multiple times. It's a pre-sold, pre-planned event. It takes some time in its organisation. With me today is Susanna and Louise, who are the two directors. They have a large amount of experience in operating bars and events here in Sheffield and further afield. Louise being an events organiser and professionally in organising events for organisations, and I think hosted events even here in the town hall on occasion. So has been in a position of trust for a lot of parties and has a long career in that. Susanna has decades of operating bars and managing bars and operations in Sheffield. I feel that before I start repeating myself, I'm going to ask Susanna just to speak a little bit about the Steamworks herself as the applicant, to give a description of what the premises and the feeling is, what we're intending to operate there. But just before I do, we so far invested about £60,000 in to get this venue to the stage it's at through the legal processes and the applications. I confirm that it's not 60,000 on licensing lawyers, unfortunately, but on others. And they've entered into a 10-year lease. So the unit is adjacent to the Portland Works, but is not owned or controlled by it. It was an empty industrial unit, and my clients have entered into a 10-year separate lease on that. So again, an investment in time and money. So if I pause there and ask Susanna to just speak a little bit more about the Steamworks, but not keeping you too long.
Thanks. Our mission for the Steamworks is to create a space where creativity and community flourish. Our team, led by two dedicated mothers and established female entrepreneurs from Sheffield, is committed to delivering outstanding experiences, blending expertise with a passion for our city. Embracing the industrial charm of Sheffield, the Steamworks is a versatile space, which we hope will become a cultural hub for the area. Our commitment to responsible practices sets us up as a venue that cares for its neighbours. We are proud hosts of artisanal markets, supporting over 100 small businesses during our Christmas market. We believe in giving back to our community and have offered parking spaces for volunteers of Portland Works. Our mission extends beyond our walls. We aim to add vibrancy to our neighbourhood, driving footfall to this part of the city. The Steamworks is more than a venue, bringing investment to an area that craves cultural richness. Our vision for the space is to be somewhere that becomes a symbol of responsible, inclusive and inspiring gatherings, We have an application system on our website that allows local community groups to apply for the use of our space during non-event hours for free. This means that theatre groups, local artisans and other community organisations can utilise our expansive venue for rehearsals, meetings and charitable endeavours. We understand the value of providing a platform for local talent and initiatives. So far, for the client inquiries that we've had on the space include a trade show, a body positivity conference, a recovery and sobriety conference, a South East Asian food fair, vintage fairs, a marketing conference, a podcast festival, a book festival, silent discos, and film screenings. We are committed to bringing a carefully curated calendar of enriching events to the area.
Thank you very much. And so I think that describes it more sort of colourfully than I can. Just before I rest, the only other matters I'd want to bring to the attention of the committee is that obviously the area itself is not devoid of licensed premises. I think the Portland Work has on another adjoining wall the Stag Works, which is licensed and has a wide number of activities, including live and recorded music, through till 2 o'clock at the weekends. I'm not privy to how often they operate them or whatever. But also Golf Thung as well, which is a close neighbour, and then obviously Bramall Lane and London Road either side. Just to put it into context, the hours that we're applying for are well within the licence envelope of that immediate area. They're some of the most modest hours again. We did apply for a larger licence that would have provided more flexibility and allowed us to do other events. But after engaging with responsible authorities and residents, etc., decided that we would start at this size, and if we can justify our operation, if we can make those additional investments, build out from there. And again, I think that's a reasonable approach that my client's taken. And I don't think there's anything before the committee to suggest that they're anything other than unreasonable. Thank you very much for your attention this morning. I'm obviously here to answer the questions that you may have.
Thank you. Roger, would you like to start us off?
Thank you very much, and thank you for your presentation. First of all, do you have sound engineers that can adjust the level of the music or whatever the sounds are coming out?
Yeah, so we don't currently have a sound system of any kind anyway, but if and when we do, we have a in-house technical manager, is what I would call him. We've so far we've only used Bluetooth speakers for our Christmas market. We just played through, you know.
Okay, right. Also, I mean, one of the problems is the bass sound that reverberates outside more than the higher notes. The thing also was, you said that it could be used as a space for any activity. So how many, it says up to 1,000, but that's not all seated, is it? How many seats would there be for those kind of activities?
For which kinds of?
You know, if you made it into a theatre, for example, for cultural activities.
Well, we have a capacity with environmental protection of 300 based on the toilet provision.
Yeah.
The fire risk assessment puts the capacity upwards of about 600 odd. So we're not filling the space as it were to our fire risk assessment. So the area, as you can see on the plan, there is a wide open space for us, and we can have seating placed on that. Of course, if we do have close seating rows, then that in itself would be subject to a fire risk assessment to see how that would affect our capacity, because those chairs can be knocked over in an emergency and things of that nature. So the capacity for the premises at the moment is up to 300, and whether or not that would be for, that technically could be for an entirely seated audience, or as it was for the Christmas market, would be the markets, the people operating those markets, and then a flow of people coming and going throughout the day. So
is there a staging area, or is it a flexible area that can be, you can put a stage on altogether? Yeah. Right.
Could I just ask a question on that capacity? So is that the number of people that you are 300 it's never going to be more than 300? Or is that when it's...
That's a capacity that that's a condition, Councillor, that we've offered onto the licence itself. So if we wanted to exceed 300, we'd have to have a vary the licence, or you could technically apply for a temporary event notice, which could apply to 499. The 300 figure, as I say, is not based on the fire risk assessment of the building, which is considerably more. It's and I think you may be familiar with these arguments, toilet provision, and Sheffield's very sort of close attention to toilet provision and the British standards. So based on the toilets that we have at the site at the moment, which are the ground floor toilets, which is what we're licensing, that's 300, that's where that figure comes from. There is actually plans to replace a set of stairs which leads to a kind of mezzanine first floor area which has additional toilets, but that would be subject to a separate application in due course for your consideration. Today, what we're asking you for is a licence that will permit no more than 300 persons, and that will be conditioned.
Thank you.
The other question I was going to ask is that it seems from your statements that the music is not going to be happening all the time.
No, music is across the spectrum, and background music for a Bluetooth speaker or a live heavy metal band or either ends of that spectrum. And we are not going to say to Portland Works or to yourselves, the committee, that this premise is set up tomorrow for a heavy metal band concert. It wouldn't, and if we did, it would undoubtedly undermine the licensing objective. Mr. Singh would have a small coronary, or you'd see the veins start throbbing in his head, and we'd have a noise being noticed before the end of the day. But that's the same for every licence application that comes before you, I'm afraid. What I want to just to say is my client is aware of the limitations of the premises and intends to improve the premises and operate within the remit of the premises until those improvements are made. Things like attenuation work, perhaps to roof or adjoining walls, will not necessarily require us to come back for licensing approval. But the engagement of Mr. Singh and his colleagues has highlighted that, made it very clear to my clients. So we do absolutely want to stress we do hear what Mr. Singh says and his concerns, and we do hear what our neighbours' concerns are. But as we've demonstrated with a couple of temporary event notices we've run in the meantime, we can operate events without causing that feared noise nuisance.
Right. I mean, this is a very important point because you need to be on good terms with your neighbours, whether they're domestic or whether they're commercial. And I mean, from what we're hearing now, it does seem that there's been compromise, and there has been a willingness to compromise. I hope that if you are granted the licence, that you will continue to engage with the neighbours and with whether they're commercial or domestic. And I hope that you can confirm that.
I think that's absolutely it. And we do thank the Chair for the Portland Works that they made time to see us. The meetings have been polite and productive. We have tried to listen to what they're concerned and provide reassurance for it. We do appreciate that if the licence is granted and we do start to do events, that we will be, our operation will be looked upon by the Portland Works. So they will be wanting to see that we provide what we say we're going to provide in a way that doesn't cause some nuisance, and we're well alive of that to allow. But absolutely, from my client's point of view, we would open communication channels with the Portland Works would be most welcome. And I think the quickest way to resolve any sort of noise issue that might be perceived would be speaking to us directly and giving us a chance to address it. That's not to say that they can't make a complaint to Environmental Protection Services, but ringing an out of office hours line in the hope that that will come back to us promptly is perhaps not always the case. We can only invite the Portland Works to contact us immediately should they have any sort of concerns. And for the benefit of the committee and the public, we are more happy to go on with it. We will try and engage productively at all times with our neighbours. Because, as I say, a 10-year lease we've entered into, we hope to be a firm part of that community and build into that community. And if anything, expand the steamworks over time. But we do recognise that if we want to expand, music, that there will be some additional works, quite considerable probably, to undertake, but we can conduct activities already without causing a nuisance.
Yeah, I noticed you said you're going to put some signs up for when people leave the premises, but unfortunately most people don't bother looking at the signs. So what other things are you going to implement to make sure that people do leave the premises, particularly if you have a really, you know, these late night events going on?
Well, as I say, it's 11 o'clock, and part of our risk assessment for any sort of operation would include dispersal from the site. So if we were having a silent disco or something of that, where we'd expect a more sort of exuberant younger crowd, we might look to have door supervisors to help us manage internally and dispersal of those sort of events. The use of door supervisors is a sort of risk assessed basis, and that would take part of our risk assessment for any sort of event. But dispersal, Council Woolhouse, is part of our risk assessment. So where necessary, we would employ door supervisors to help us with that dispersal. And I think one of the things that the Environment Protection Service wanted us to do was to put temporary barriers opposite our exit so people don't spill straight out and onto the road, and that they go left and right or onto the pavement. So there are some specific measures we've already agreed to, but for the nature of events, because we are eclectic in the type of events and therefore the type of customers and what hours we're operating to, it's not a position where we would have door supervisors for every single event. And we wouldn't agree that every single event ending at 11 o'clock would be dealt with the same way. It would depend on what that sort of event is. I think you talked about a meeting for sobriety and things of that nature. They probably, no pun intended, less sober, or more sober rather when they leave than other people utilising the bar. So we would look at events. But dispersal, knowledge of dispersal, we recognise our responsibilities to manage that also.
You're saying this is very much going to be an event space. I just wonder what happens in between events. Is it going to be open as a licensed premises, or is it just for events?
It's not going to work. What was going to see the Councillor?
So as well as an event space, we have a number of first floor studios that we're leasing to small businesses. So it's the combination of those two things that make up our business.
And the other thing, as an event space or a community space even, you may well be responsible operators, but how do you control the people that are using that space that aren't you?
So we have I can't remember his qualification, but we have someone kind of on the books who's a qualified health and safety person. I think you know him, Bob Ollie Galvin.
Yeah. He's a health and safety advisor consultant, major large scale events nationally, locally.
That's what he is. And he will give us a client pack with all the obligations that anybody who hires the space has to provide him with to make sure they're running the event properly.
And then obviously, as apart from Susanna's experience as operating bars in Sheffield and beyond, the risk involved in using promoters and externally promoted events are alive to those as well, to identify known promoters, people that you have relationships with who aren't going to burn you with operating, sending people to your venue that aren't as described, etc. So, a lot of experience in identifying those type of events, but because of it being a community event with lots of different types of operation, we will be engaging in different type of, not necessarily promoted events, but a range of different clients and people wanting to use it. But part of Susanna's experience is directly related to that, and also Lucy's own experience in being that person who runs those events and puts those events on, gives them both a good level of expertise to identify what are appropriate events and recognising events that may not stack up, as it were. But the ultimate operation of premises would still lie with them as operators, and that's a risk that they have to accept and freely do so.
And just finally from me, as it is events, presumably there'll be advertised well in advance, so other users of the site will be aware of what's happening and when, with quite a bit of notice.
Absolutely. So and there's a mixture of events and sort of engagements or conferences. So a user who wants to put an event on, so it's not necessarily a public ticketed event and things of that nature as well. So there's a mixture of both of those. It's not simply going to be, you know, a birthday space or a concert space or that. It's going to have, our business plan is, we've recognised that this sort of space, this size of space in Sheffield is in demand from all these different sort of groups, and that's where we think our kind of USP is to offer that space up. But a lot of our events, you know, during the day, wouldn't really even engage any of the licensable activities. It's just that a number of them will, and that's why we're coming for the licence.
Thank you. There's nothing more from me. Sam, is there anything you would like to ask the applicants?
Just a couple, thank you. I think you have already clarified that it's on sales. I did read in your note that you said on and off sales, but just to...
I think it is just on sales. Let me just check the application.
I think the application was, yeah.
Yeah,
We're
not trying to... No, if it should be just on sales, so we're not looking for alcohol off, or is that in the bar? See the alcohol?
You had one stall holder, but...
The only time that we utilised off sales was the market we had. Excuse me. The only time that we used off sales was for the Christmas market, and that was people buying sealed bottles as gifts, etc. But we used that as under a temporary event notice. So again, if we did have a future market, and we'd probably just use a temporary event notice for that single event. We are just limiting alcohol to consumption on the premises.
And is the alcohol licence just to offer flexibility for events? It's not sort of a backdoor way of having deregulated entertainment?
No, the hours that we're offering are from 12 o'clock, so as you're correct to say that deregulation is between 8 and 11, but only when the bar is open. So I suppose if we were trying to circumvent it, we would apply for an alcohol licence at 8 in the morning through to 11, which we're not. But, you know, so the sort of events we'd have during the day, an event around about or finishing at lunchtime or after lunch, that like catering and maybe some glasses of wine with that, we can see that as a possibility, hence a 12 o'clock sort of start time for that. And generally sort of operating, you know, 12 o'clock is a fairly modest time to start a bar with the Lyceum 2003. It's not always that time. So, yeah, it's normally ancillary to the events that we're envisaging. And some of the events, I suppose, Silent Disco being an example of one, you know, it will be a bar, it will be utilised as a bar for the people at the event who want to buy drinks and be operated as well, not as a catering service, but as a traditional sort of bar where you pay your money, you buy your drink, and etc. So it does cover that, but that's by its nature being quite an eclectic venue.
Thank you. I was just looking at it on Google Maps because I'm not massively familiar with the area. Do you back onto Golfang then? Do you share a wall with them? And do you ever get noise from them? Do you ever hear them?
It's very dull when it's there. It's nothing that would intrude on anything that we would do.
Because I think they're open until about midnight. What, they've got a licence until midnight? Yeah. Okay, so you've not had issues from them then? Okay. I think that's everything from me. Thank you.
Do the responsible authorities have any questions for the applicants, Bob?
No further comment to make.
Do the interested parties have any questions for the applicants? We'll start at the right-hand side and work down.
I don't. We had some productive discussions over the last few weeks where there are points to be resolved. I think we resolved them, and as far as the society is concerned, it's this issue of noise, whether it's films or music, and we'll suck it and see.
Do you have any questions for the applicant?
Not a question, just a point relating to what the solicitor was saying. You mentioned that Stagworks has a licence and an adjoining wall with Portland Works. I just want to make the point that it doesn't have an adjoining wall with Portland Works. There's actually a gap of about 5 metres. So there's no adjoining wall.
I'm sorry, I was looking at it on Google Maps. It looked like it did, but I apologise. I'm sorry if I've misled. I apologise. It's another close neighbour. I'll leave it to that.
The other point was you also mentioned that you'd received complaints had been received about the premises when it was industrial as well.
No.
All right, I misunderstood that then.
Sorry.
Okay.
And do you have any questions for the applicant?
Yes, if I may, just something that's occurred to me during the discussions. It's quite clear that No Mile Steel are very serious about, managing the facility responsibly within the terms of whatever requirements they're legally supposed to meet. But given such a variety of different activities, I'm just wondering a question. Are you proposing to rent your premises out to third parties? I'm just wondering how the management system works, because it's a bit like Airbnb. If you rent your premises out to third parties, then all hell could let loose. So I'd just like to learn a little bit more about, say somebody comes along and says, I want to hire your whole warehouse. I've got this great event I want to run. How do you deal with that?
We'll be on site to manage that. So we don't just hand the venue to somebody and leave. As part of our business model is that we'll be present, or an event manager on our behalf will be there at all times to make sure everything's managed well.
If there are no further questions, then it's over to the applicant to sum up your application.
Again, thank you very much for your time today. I believe this is a modest application in a reasonable form, and my client's conduct of the application, I hope, will give the committee some confidence that they are responsible and reasonable persons. I think that is the position that you must adopt unless you know to the contrary. Absolutely, that isn't the case, and you haven't given any indication, so I'm going to presume that's not the matter. I appreciate the anxiety and concerns about live and recorded music that's been expressed, and my client recognises that there is some work to be done at the premises that will, until it is done, will limit the type of operation they can have at this site. They do believe that some level of recorded music is possible. They've demonstrated that with temporary event notice and things of that nature. But heavy duty bass live performances, yeah, absolutely. We would agree that wouldn't be appropriate, nor are we proposing that. The granting of the application today, if that is how you're so minded, does not change that position, does not change the point of view that my clients have to promote the licensing objectives at all times, including prevention of public nuisance. As I've said to you on many occasions before, we're asking for permission to carry on licensed activity, not permission to cause or undermine licensing objectives. We recognise absolutely that that's an ongoing responsibility for my clients. Thank you very much for your attention today and everybody's participation and coming along. We do appreciate that. I would imagine most people have better things to do with their time, but thank you very much for your attention today, and we simply recommend the application for grant.
Thank you. Better things to do than come to licensing. Surely there isn't. I can't think of anything. So could we have the options, please, shouldn't there?
Thank you, Chair. The options open to the committee are 1, to grant the premises licence in the terms requested, 2, to grant the premises licence with conditions, and 3, to reject the whole or part of the application.
Thank you. Can I now ask people to leave the room while we take legal advice and come to a decision? If you want to hang around, welcome to come back in and we'll announce that decision as soon as we come to it. We shouldn't... Right, well, welcome back everyone, and thank you for your time and your representations this morning. The decision of the subcommittee is to grant, as applied for, subject to the additional conditions proposed by Environmental Protection numbers 1, 6, 7 and 8, which I believe you volunteered to accept anyway during the course of the meeting.
We did reword condition 1.
It's-
Yeah, okay, that's reworded. Thank
As
you.
worded for regulated entertainment, yes.
Thank you.
And just for the interested parties' sake, as the applicants did say, the Licensing Act is a very permissive piece of legislation. It presumes that operators will be responsible and will not cause problems. And in the absence of evidence, hard evidence to suggest there are problems, we have very little option other than to grant. However, if there is subsequently evidence following the granting of a licence that there are issues, then if they go there this afternoon and start causing you problems, you can request tomorrow that the licence is reviewed and people will come back here and we can put on conditions or revoke a licence. So it's quite strong in that respect, but in terms of new licensing, without evidence to suggest otherwise, we presume that these people, and we hope they will be responsible operators, that you'll work together and that you'll have a good relationship. But as I say, if it doesn't work out, and I hope, don't take this the wrong way, I hope I don't see any of you again in here, though I'm sure I'll see Bob at some stage. But you do have that route back if things don't work out. And I'd say thank you again for your time and your representations this morning. It's been helpful. And that's the decision of the subcommittee, which I believe is appealable, isn't it?
It is, yeah. Sorry, just the less interesting bit at the end. Everybody gets a right of appeal today because we've granted your application with conditions and because contrary to representations, we have granted the application. So should you wish to do so, it's within 21 days to the Magistrates' Court. Following the hearing, you'll receive a notice detailing all the evidence before the committee, how they reach the decision, and just confirming the conditions that will go on the licence. Just so you've got that all in one place, but you do all have the option should you wish to exercise it. But again, thank you everyone for your time today and appreciate it's not the warmest of rooms, so I'm grateful for your time. Thank you.